we have launched.
Yes, we have. Welcome, everybody. Planet Green Trees. Officially, Planet Green Trees. Episode 185. We're calling it CBD Only. Hartwick, Tuttle, and I want to amend it to Trebeek. Today's February 6, 2014. The call number is 347-326-9626. Visit us at www.planetgreentrees.com. We want some call on some of these exciting topics. I'm your host, Michael Komorn of Komorn Law. Side with me to bring you only the best and most entertaining and up-to-date, informative radio blog show about medical cannabis and cannabis reform.
Chad up to the minute.
Chad from the Birmingham Compassion Club.
Thank you. It's nice to be here.
It is kind of up to it's hot off the presses. We're going to start with just other major breaking legal issues from this past week and the impact it had, and then we get another one. And helping us bring this is going to be the other contributors to the show, our good friend Rick Thompson from the Compassion Chronicles.
Hi, everybody.
Of course, the renowned producer of Planet Green Trees and the leader of the Third Coast Compassion Center, Jamie Lowell. As the title suggests, tonight we're calling part of the show CBD Only. CBD Only based legislation creeps into the mix some states where marijuana reform and medical marijuana is being legislated in dispensaries and provision centers. Bills allowing for cannabis without THC have been discussed or introduced in Florida, Georgia, Wisconsin, and elsewhere. The American Rights Conference series begins this weekend in Lansing, and it also scheduled for next month in Grand Rapids. That was a segue that was not really clear. There's also been another hideous ruling by the Michigan Court of Appeals, People versus Tuttle, which seems to further enforce the watering down of the affirmative defense from previous rulings in the Hartwick case. And those are the three topics we're going to be talking about, joined, of course, in the Trebeek case. But joining us tonight in the special guest, we have Gary Stork, member, board advisor at Patients Out of Time. He's a citizen of Wisconsin where the CBD only legislation is being considered. Standing in place of, but it's kind of difficult, but a battler in her own right, Robin Schneider is going to be calling in, one of the representatives of Michigan Moms United and also a lobbyist for National Patient Rights Association and really the hardest working woman in Lansing for the medical cannabis community. Robin Schneider. She's going to be speaking of tonight in place of our good friend Sharmi, who apparently cannot call in, about this upcoming event called the American Rights Conference, and also all the research related to the CBD only proposals, and we'll be discussing this topic as well as this weekend's conference in Lansing and the other things that those may expect should they desire to show up. And we're encouraging everyone, of course. I'm going to be there. I think I'm involved in one of the opening ceremonies. Still not all showed up yet, though. Also discussing recent news in local communities concerning dispensaries for patients in Walled Lake and in Bessemer in the Upper Peninsula. I'm going to rant in a little while, and Rick is going to do his news and all kinds of stuff. First, before we get into this, I want to give a big thanks again to what I would describe as very inspiring patients who participated in the defense of cannabis oil. And John Roberts a couple weeks ago in St. Clair County. I can't tell you, I'm still thinking about the distance that you traveled and the compelling stories that you told, and I'm going to refer back to this as we discuss some of the things in the rant. Of course, big thanks to Pam and Dewey. Dewey, I missed you this past week. Dewey's been sick. I hope you're feeling better. I'm going to expect you bright and early on Monday. But as I said last week, Chad tried to help out this week, get me places, and Chad...
I think he's ready to go.
You're right. Chad's ready to go, too. Chad said enough. Of course, the Michigan Medical... All right, I don't know what happened. We've already...
We've been through space and time now.
Little vortex interference there. I think we're okay now. I was thanking in the last moments the Michigan Medical Marijuana Association, Komorn Law, 1-800-656-3557. The Marijuana Rancher, 313-422-5281. Call and get a appointment for cultural tour of the Hemp and Cannabis Center. Also, I understand the Rancher is participating in the sponsoring of the event this weekend in Lansing called the American Rights Conference. Sharmi Golson and, of course, Robin Sean will be calling in for that. Dr. Kumar Singh, Greenlight Clinic, 248-390-0574. Usually this is when I start talking about how important it is that you have a bona fide relationship and you have a doctor who will testify for you.
It's getting clearer and clearer.
It's going to get worse. I'm going to avoid what I
day.
usually say about Dr. Kumar Singh, only to say that everything I've said before is even more convincing, and you'll hear about this in the rant.
And there will be no doctor certifications done on site at the American Rights Conference, so we're happy about
Great
that as well.
news.
I think what was mentioned in that was not a bad idea, which was to maybe see the person, talk to a doctor,
Analysis and
then come to the
scheduling.
office. Right, exactly. I do want to say a couple other one other point here, which I guess will also lead into the rant, which is the talk with our good friend Bob Redden today. His name is back in the many of the new opinions. You thought that was over. You thought that first opinion went to the Court of Appeals, and that really atrocious
concurring
opinion by Peter O'Connell that we've given up on the Bob and Tori, but it snuck its way back and is being referenced only to really make an important point of detracting or taking away from the value of the physician certification, independent of whatever the seriousness of the condition is. And I mention this because as I spoke with Bob today, he has given me an update as to Tori's condition. For those that don't know, Tori, who at one point was described in court by the one of the prosecutors in the case, that judge, she only has ovarian cancer. Well, Tori's now been admitted into hospice. Bob, of course, has moved her back to his house and is caring for her now, trying to make her as comfortable as she can be. And my experience with the John Roberts Section 8 hearing and all those courageous patients, speaking to my good friend Bob, I could tell the heavy heart that he was talking to me with and the feelings that he had. I'll tell you that life sucks when you're sick. And people should have a right to choose what kind of medicine they want to use to treat their conditions. And I think it's outrageous what we're about to talk about tonight, some of the things that have fortunately found their way into our discussions here at Planet Green Trees. Okay, so there's been two significant cases that have come down in the last couple of weeks. One of them is People versus Hartwick, and the most recent one, People versus Tuttle. And both of them are an appeal from a trial court in Oakland County where there was a ruling that the defendant's presentation of their Section 8 defense and their motion to dismiss was denied. Their motion in lieu of dismissal to be allowed to assert a medical marijuana defense was denied, and instead the defendant opted for their third choice, which is an appeal to the Court of Appeals, and the Court of Appeals didn't want to hear it. So Hartwick had to take his case all the way to the Michigan Supreme Court, who then in turn forced the Court of Appeals to hear and listen to the arguments that were made there and come up with an opinion, which they did, and which I'm going to talk about in a second. Also, the same can be said about People versus Tuttle, which was an opinion that around the same time, October 2012, was appealed after being denied the right to present a medical marijuana defense and not in dismissal, and the Court of Appeals rejected hearing any arguments on it, making a ruling, and went to the Michigan Supreme Court, where they also ordered the Court of Appeals to address these issues. Now, when I analyzed Hartwick, I always felt like, my presentation of a Section 8 would never be what Hartwick did. And you have to understand what Hartwick did, and not that I don't believe that the law would allow for it, I just know that the way in which it's being interpreted and the criticisms by which the prosecutors and judges have been analyzing it, the straight-up Hartwick strategy would would not be my first choice. Do I think it should prevail? Yes, I do, but for different reasons. But to understand what I'm talking about, you have to understand what Hartwick tried to do. And likewise with Tuttle. Hartwick showed up for court. He had allegedly 78 plants, although that's in dispute. And, of course, the arresting officer in that case was the one and only Detective Ferguson, who was later fired from the Oakland County
Proved to be a liar.
Sheriff's Department for lying in an affidavit called out by one of the assistant prosecutors up there, and then I believe she was later transferred to another unit. Nevertheless, the plant count was 78. Hartwick goes to a Section 8 hearing, and he sits on the witness stand and says, here you go, I got 6 cards, and admitting them into evidence, essentially kiss my you-know-where. And when questions offered by either the court, the prosecutor, or even his own lawyer, he was unable to count for the names of his patients, 2 of them. He was unable to count for their interactions with the physician, who their doctor was. No testimony came forward establishing the requirements of prong 1 of the patients to whom Mr. Hartwick was relying for the marijuana that was at issue, and to which patient it was going to be used to treat their serious or debilitating condition, which is really the prong 3. Meaning, you're going to need to validate your belief, your intentions of what you were going to do with the marijuana, the cannabis, and to whom it was going to be provided. If it's a patient whose plants are being grown for themselves and you're over, or you have too much material in your patient, then it would be you describing the intent and how the medical necessity of that marijuana is going to be used, or cannabis is going to be used. But you're going to need to also substantiate the other prongs as well. What the Hartwick case says is that because Hartwick was unable to satisfy the prong 1 for his other patients, there was no doctors who have stated in their professional opinion, after having a bona fide relationship with the patient, that the patient meets the criterion and may receive therapeutic or palliative benefits, with a extended version of what bona fide means after, if your case is after 2013, and an even worse definition of what bona fide may mean that you would not even know about, because the interpretation of how the doctors are supposed to be treating the patients is being used now by the courts from a memo that was sent to doctors, not patients, not caregivers, meaning patients and caregivers have no notice of what would be required of them pre-2013, and now the courts are essentially utilizing the what we call the LARA memo, which was a recommendation sent out to the licensed physicians, all of them throughout the state, indicating what the protocol should be. And while it doesn't say mandated, there's language in there that talks about suggesting a pre-existing condition relationship with the certifying physician, to the extent that if you don't, you may not be participating in a bona fide relationship. Now, I don't think that the Lara memo says that. I think it's recommended. There are other very clearly identified and articulated requirements that are symmetrical with the amendments to the bona fide doctor-patient relationship as of 2013. But and I don't think that this other requirement is something that, but I've heard horror stories, unfortunately, from brother counsel who have had Section 8 hearings or rulings, opinions offered and issued by judges and referenced that aspect of the memo, and in light of Hartwick and in light of Tuttle's. But what's important from the Hartwick case, before I briefly go over Tuttle's, is that there are some positives for purposes of Section 8. Number one is that Hartwick himself, while he wasn't able to substantiate the other patients that didn't show up by just presenting the cards, he was able to satisfy prong 1 of Section 8 by his own testimony, his own card, the statement that goes along with the card, the implied statement, and his own testimony. Now, he was also arguably able to substantiate the reasonable amount. Actually, I take that back. He wasn't able to substantiate the reasonable amount he needed because he wasn't able to talk about it. He wasn't able to articulate it, and he relied upon the statutory amounts in Section 4, which, as I say every week, or I don't, I'm saying it now, and it very, very clearly outlined in my pleadings whenever I filed these that Section 4 has nothing to do with Section 8. The amount in Section 4 arguably could be too much, it could be too little, but it's irrelevant. And when you go to trial or when you have your Section 8, those numbers do not matter. And you're going to have to be able to state why it is, what your intentions were, how much of it was going to be used by whom, and verify this, corroborate this information by way of patient testimony, statements by the physician as to their debilitating condition, and other things that are necessary. Now, I do think that, for example, had Hartwick called his patients did not have their physician come in, that by the patient's testimony, and Hartwick would support this, if he had his 5 patients come in and testified, they had their card, had their certification documents, and were able to testify to evidence of a bona fide relationship, meaning they would testify to what took place with the physician, Hartwick may have been able to substantiate it. One of the things that's outlined in Hartwick, which I have a problem with, is that they suggest that put a burden on a caregiver to have some interactions with the physician, or said another way, that the doctor himself or herself would somehow have a requirement to direct the patient as to how frequently they're supposed to dose and what method of ingestion and what strain and what have you. This, I think, has gone way too far. We're way, way away from what the intent of this law was. I want to remind anyone that cares that Hartwick is an error. I do anticipate it's going to the Supreme Court. Last week we were talking with the attorney that handled the case. I understand the Supreme Court wants to hear the case, so all this may be for naught. One of the things that you cannot help but to notice in error is that the court clearly discusses the entire process of getting a certification as if it is and uses the word prescription. That the entire premise by which they analyze the act and the burdens by which they place on the physician who's doing the certification is the equivalent of a doctor that writes a script. And this is terrible. It's wrong. It has no bearing in the law, and there's a number of reasons for that. First of all, this is not a prescription. This is a Schedule I drug, allegedly. It is, even though I argue it's not, and so do the people of the state of Michigan. Nevertheless, Schedule I drug, and for DEA license purposes, no doctor should be getting involved to the degree that the Hartwick court demands. And it's a dangerous road that we're going to go on to require the physicians to actually participate to the extent that the Hartwick case asks them to. Let's go over some portions of here. In Hartwick, they declare that the defendant incorrectly states that his possession of the state-issued medical marijuana card is enough to satisfy the requirements of the bona fide relationship. Certainly, possession of a card does not demonstrate an ongoing relationship with a physician envisioned by the MA, where a doctor can prescribe a certain amount of marijuana for use over a period of time. This is one of the most egregious. They footnote here some references to Keel and overruling it, which was a unpublished opinion. And I think that this is a dangerous place because the physicians really don't have and aren't required to. I remember one of the physicians in the case that we fought out in Livingston County, where the physician said, look, the state gives us a criterion of what conditions are going to be helped by the use of cannabis. I'm examining the patient, I'm developing a relationship with them, and if they meet that criteria, that's it. I don't know how much, nor should I know how much marijuana to use. I'm not going to tell them what to do. I'm not prescribing them a Schedule I drug. I'm recommending it. It's like recommending that you take 2 aspirin and get a good night's sleep and call in the morning, or take an Epsom salt bath, or have a glass of orange juice. None of those things require, how much Epsom salt or how much orange juice to use. It's literally a recommendation. Now, I understand that because it's a Schedule I drug, allegedly, that the requirements of some kind of follow-up and overview, that's more, I don't agree with it, but it's something I can...
But it's not Schedule I really by definition.
Well, but I understand...
Anymore.
I understand that, but I'm saying I have less of a problem between the two, that the doctor's going to be involved with determining, or it's presumed that where a doctor can prescribe a certain amount of marijuana for use over a period of time, the doctor in no way, shape, or form is required to know or participate or get involved in the dosing, frequency of use, or method of ingestion. As we said last week, I think the Section 6 regarding the minors who are ingesting cannabis by law are going to take that direction, not from their two certified physicians required by law to them and get a card, but instead by the caregiver, who in this case would be the parent or legal guardian. If you remove the child aspect of the law that brings this or places this burden or task upon the parent or legal guardian, it would be the caregiver or the patient themselves. I've been in the minutia of this, and I think that it is ridiculous that you're going to have a very difficult time asking any physician to go there. I mean, after all, one jar of marijuana that's 1 ounce, 2.5 ounces, that's high CBD and low THC, which is one of the topics tonight, or high THC and low CBD, may have a completely different impact on any different person. And that person's impact and whatever their condition is going to be affected by their multiple factors within their own chemical makeup. And the idea that we're going to have some kind of absolute or consistency over and over and over again, I think we're a little ways away from that yet. And I don't think that the requirement to do this could even be substantiated if really pushed. Maybe in over the years there's evidence of certain strains that are affecting other ones. I mean, I heard today that a neurologist recommended a Canatonic, the high CBD strain, to his neurology patient who has seizures or seizures. What is it called?
Epilepsy.
Epilepsy. And we're right on top of it. Neurology, yep, absolutely, and new strain. I think that's an interesting dynamic. And but still, if it is, it's only because it's a high CBD, and not. And the entire other range of various strains would be still up in the air. Not enough absolutes in terms of testing and in absolute consistency with production. But I think we're getting there, and I think that if the physicians start getting feedback from the patients in their ongoing relationship over a period of time, that they will be able to actually begin to identify what strains may be working for certain conditions. And I think that caregivers who are interacting with patients want to make note of those things as well, so that they can share the information with their physician of the patient on behalf of the patient and keep the physician informed. What I'm saying ultimately is these cases are terrible, that they place an almost unworkable bar that is going to be torturing the patients. I again find it extremely difficult to accept that an individual who's asserting a medical marijuana defense, a defense that is a right under the Constitution to assert a defense if the facts support it, could be deprived of that defense because of a third-party interaction between a physician and a patient that may be good, bad, or otherwise, but is somehow going to directly impact an individual who is looking to exert a defense to a case. I think that is patently egregious and violates every tenet of due process and constitutional principles, or at least my personal constitution, because it goes against the grain of every aspect of Michigan and American jurisprudence. It just doesn't happen. You just don't let things like that happen. Now, you may attribute guilt for other third parties' bad actions, but never to deprive someone of a right. And the idea that the person who is being deprived of the right, the caregiver or the patient, because of the doctor's activities, is another outrageous burden because, as I stated, the memo the Lara memo that is going to hold a doctor to a standard is not something that was published to the general public. It's not a law. An individual could honestly say, I had no idea that existed, and you're telling me that in order for me to use my card or to assert a defense, I have to have a pre-existing relationship. Show me in the law where it says that. It doesn't. Show me someplace where I, as a patient, would have had notice of it. There's no place. But you're telling me the doctor knew, should have known, and therefore because the doctor didn't do it right, I, as a caregiver or patient, I'm not going to be able to. This is insane. And it's a bad direction to go. I will say this in and I'm going to wrap it up right here. We're going to go to a break, but I had, as I've been talking about these courageous patients that came all the way from all over the state. I mean, one patient drove all the way from Traverse City, 4 hours. Like, I talked to her at 10 o'clock the night before, and she was getting up at 2 to drive, something like that.
Dedication.
To tell her story. I mean, these were the patients that the Michigan voters identified when they passed this law. These are the cancer patients who had gone through every last batch of chemotherapy and radiation and were told to prepare a will. They were told to get with their loved ones, to make amends with whoever they had fights with, and to try to enjoy the next year or two, not knowing really what was going to be out there. They know their recommended treatments for them, that many of these tumors or cancers that were growing in their body were too close to their brain, and another treatment of radiation would destroy them. A biopsy of it would potentially sever their spinal cord. So the ideas were that they were just on their own, and while they had oncologists, and they would check periodically every 3 months or so the growth of the tumors or the blood levels of their white blood cells or other indicators of how their cancer was what state it was in after they'd stopped treating them. Under no circumstances were these doctors continuing to treat these patients with any kind of bona fide relationship. That they had an oncologist. Their oncologist had recommended medical cannabis for them because there was really nothing else. And if there was some other even suspicious type of treatment that they could, the doctor would have recommended that as well, because there was nothing else for them. But to suggest that these oncologists, in 3 or 4 of the cases of the patients who testified, that their act of signing the form, somehow they're going to be required to know what strain is going to be best for the patient, or what food product to eat, and is just insane, because it's just not going to happen. And even though these cases really narrow and create a threshold for the doctors, I mean, there's a number of different statements that are really the core of the act, and I want to just refer to them for a second here. And it really goes to what the purpose of the act was, and that was so that the sick people who have debilitating conditions would be able to utilize cannabis. And I'm looking for my specific language. But the point is that at the end of the day, the Michigan Medical Marijuana Act was specifically enacted so that the most seriously ill individuals could utilize cannabis and not fear arrest or prosecution, and at the very minimum be able to assert a defense, let a jury decide whether or not the medical use was warranted. And I think what's happening in these 2 court opinions is outrageous. And when we return from the break, we're going to talk about some positive Court of Appeals opinions. But it really goes to one of the things that it's unfortunately become my mantra on the show: get with a doctor, have a bona fide relationship, make sure they're looking for medical efficacy, benefits of the use of medical cannabis, and just shut down the one hole in this act that's being exploited. And who knows, maybe your doctor will actually find a strain that can, with your interactions with them, find a strain that will help some other patient, and you can feel good about that. So there's a lot of positive ways to look about this. And also, I think it will definitely assist in other physicians becoming more engaged in it, and it'll become much less of a big deal in most practices. But I think that the patient community, at a minimum, needs to take more responsibility for their charts and find the doctors that are prepared to engage in a real relationship that's in compliance with the Act. All right, that's my rant. Probably a little too long. I didn't get any dirty looks from the producer. When we come back, we're going to talk about Trebeek. We're going to get right into it with our guests, and some news from Rick